Welcome everyone back to another. Oh, okay, yes, I'm starting now. Welcome everyone to another edition of Mortgage Law Today. As usual, we have a representative from Polunsky Beitel, our generous sponsors of this web show, whatever we're going to call it. It's not a podcast, I'm told. Any event, I'm Peter Idziak is with us from Polunsky Beitel. We also have guests Josh Weinberg with First Line Compliance and Troy Garris of the Garris Horn Law Firm. Welcome everybody, and welcome to all of you. I'm here in Hawaii, so I'll give you a quick view of what I've got outside my window: the boats, the ocean, and I'm talking to you, and I'm not out there. So in any event, we'll go ahead and get started. Again, I want to thank Polunsky Beitel for sponsoring the show, and off we're going to go. We've got a couple of topics I want to hit today. First of all, I know that Troy's firm reported on this. I think it was maybe his partner Rich Horn reported on the CFPB is pushing a regulatory agenda into the Office of Management and Budget, which requires a sort of a pre-look at proposed regulations. And one of the things that they put in that pre-look was had to do with LO compensation, the LO compensation rule under the Truth in Lending Act. And all it said was rescission, which could mean a lot. I guess I'm curious, Troy, I know you do a lot of work with LO Comp. Curious, what are your thoughts on that? What do you think that's all about?
Yeah, I think it's, the word rescission carries a lot of weight potentially, and also says very little potentially. So I think one of the big aspects there is this some sort of a monumental change in the way that the CFPB would approach the loan originator compensation rule? I think in some ways it would be fantastic for someone to have a good heavy look at what the rules are and whether they're actually working all these years now, after first the Federal Reserve and now the CFPB has jurisdiction over these rules. And there are a lot of places in particular that you guys probably get calls about all the time, same as I, things like, can the loan originators bear the cost of a concession, or the simple ideas about bond loans, can you pay less for bond loans, certain things like that, those questions come up all the time. The NBA has been pushing it for a long time to try to get those changes. If they actually mean rescission and taking the rule and essentially kind of unwinding or throwing it out and maybe starting over, there probably could be a lot of ways that the industry could help guide, and NBA could help guide a rule that works way better for everyone, including consumers, I think. Now that's from the lender's perspective, right? And consumer advocates may think differently. But I think there's a lot that could be done there. If you just throw it out and go back to the law itself, the Dodd-Frank statute, that there's a lot of mystery into what that means and how
there's a lot of complication with that.
Yeah,
I mean, that
would be, yeah.
In fact,
I'd add just two
ahead,
quick
Josh.
points. That the chorus I've tended to hear from industry around the LO comp rule has largely been, look, enforce the rule or get rid of the rule. But the lack of clarity, the lack of enforcement, the lack of consistency in enforcement has led to unequal playing fields, because there are some who have taken the position, not my risk for today, I'm going to pay however I want, or they're not going to enforce this rule, so I may do. And there are others who may have had experience or who are just taking a more risk-averse position of saying, no, we have a pretty good reading on what the LO comp requirements are. We're going to follow them because that's in line with our culture of compliance and risk appetite. So I think that's part of the noise or the voice that folks at OMB were probably listening to or trying to respond to. I agree though, and I actually think to two of the industry's best lawyers in LO Comp, I think it's a really with Troy and Brian. Peter, you're a little outside
A
your niche, I
little
think.
below there, yeah,
Yeah,
yeah.
no, no. But really, we had the Fed rule, which moved to the CFPB, which I believe the LO comp was part of the statutorily required components from Dodd-Frank,
Yeah.
especially under a Loper Bright environment where the regulators don't have much room to interpret the statute.
Well, this is, I mean, rescinding the statute doesn't just happen because the CFPB says it.
Well,
And
and
rescinding the regulation
the
even
rule,
doesn't
yeah,
just happen
that's right.
because the APA, probably the Administrative Procedures Act, probably has additional requirements in order to rescind a rule that was validly issued under the APA.
Yeah,
Um, that's and even if they do that, there's some definitional issues as to what's going to happen because you still have the statute in place, right?
yeah,
So you get rid of the regulation, you still have the statute, and the statute has some holes in it, some big holes that needed to be filled by the rule, that were filled by the rule. And then the question becomes, well, what happens with that? So if you really want to rescind LO comp, you have to change TILA, which is Congress needs to act.
Right.
Um,
hmm.
Otherwise, just rescinding creates a lot of complications for the industry as well.
Well,
Uh,
and yeah, and not just complications, but there are, provisions in the rule where the Bureau used their adjustment authority to allow, like upfront points and fees on lender paid and brokers being able to pay differently. So to folks who maybe think like, oh, without the rule, we're in a better environment, not necessarily so.
Peter, correct me if I'm wrong, but I think that there's something in the statute that, unless the rule permits it, that prohibits the payment of prohibits borrower paid fees entirely. Am I wrong about that?
No, I
It's a,
mean, yeah.
yeah,
Go
go
on,
ahead.
Troy.
I was just going to say it's a little unclear, but there
Yeah.
is some very broad language, and it does talk about origination points and fees and however denominated. So, there are a lot of restrictions that somebody can read into that. Now, does that mean that you couldn't pay at all? That there are probably just ways to do it differently. I
Mhm.
will say though that one of the things that I've always had concerns about with the CFPB, and this is probably true for everybody, is the CFPB, the Congress in Dodd-Frank reacting to a serious problem at the time and hoping some way to fix that problem with a sledgehammer, even if it may have been calling for something less. They created these broad requirements under the law, and then the CFPB usually had some ability to create waivers and exemptions and so on. The CFPB seems to have taken that and said, okay, now we have this language. It says we can do waivers and exemptions, whatever that means. We'll just interpret that very broadly. And now let's just create the law as we want it.
Mhm.
And really overreached a lot, I think, in the way that they defined the provisions and then how they structured the provisions in LO Comp. A lot of other places too, but that's the approach it took.
Yeah, I've written quite a bit about, sort of the LO comp is a bit of a regulation in search of a problem today.
Yeah,
What is it trying to solve? We
right,
we had issues with borrowers getting steered into products which they couldn't succeed in the
right,
pre-meltdown era, stated or option arms or whatever, negam, take your pick. Um, that problem no longer exists really in the marketplace, largely due to the ATR provisions of TILA, the ability to
right,
repay. I mean, my position has been that, ATR took care of that. If you have a customer, and they have enough income to support whatever loan product you're putting them into, and you've done a reasonable analysis of that, that's as far as we need to go in terms of worrying about, what are they paying for this product? If they
right.
can afford it, and they can shop, and we've TRID also to enable them to shop and see these numbers and understand the lifetime expense and all the things that they need to do to shop. why do you need an additional rule that prohibits certain compensation to originators? You know, what other industry has that? You can buy a car
Yeah.
without, you know, this is how people
Mhm.
shop for cars, and they negotiate with the dealer, you know, on their, and they can lower their commission if they want to cut a deal.
Right.
We have this rule that doesn't permit it. It doesn't make
I
sense
do,
to
I do think there is some help in the disclosure side in the yellow comp rule, in the sense of, you know, they strike it as a prohibition, but it could be done differently too. It's in the law as a prohibition, so you'd have to change the law, like you said, Brian. But the the disclosure essentially being forced out of, either you get paid by the consumer or by somebody else, but not both. And I think that provision, it really helps in the sense that most people, you know, prior to Dodd-Frank, they had no idea how the loan officers and others were getting paid. And so they didn't know that a lot of times that people were getting paid both by the lender and then also by the consumer. And it's all just kind of difficult to compare apples and oranges, to compare apples to apples rather. And so I think that part helps, but the CFPB took it in a way that, you know, I think, and Dodd-Frank takes it in a way that I think is beyond what really would help the consumer and allow for a free market type of an environment to function well.
Yeah, I don't know to what extent the agenda right now in Washington at Congress is being set by a deregulatory kind of environment. Is there any kind of legislation that's going to be proposed to address the, you know, TILA directly in the statute? I know that there's some discussion of lowering the CFPB's or changing the
Budget, yeah.
CFPB's funding source, right?
Funding, yeah.
Um, but I mean, I would hope that there's also other specifics that they would address if they are really trying to have durable deregulation as
Sure.
opposed to sort of, you know, interpretive and not very durable changes implemented.
But
Yeah,
you know, I do think one of the problems you'll run into, and it's not just LO comp, is that Congress has written these rules assuming that the regulators will come in and sort of fill in the blanks, like LO comp, like provide a definition of terms of the transaction. And if you have regulators that are like, well, we're just going to rescind the rules, but you don't have Congress that's willing to come in and sort of write more, you know, precise definitions, then I think you end up in maybe not an ideal situation where, and maybe this is sort of along the lines of Loper Bright, you know, it's a lawsuit, goes to a court. Then you have one judge in one district says, you know, it means this, and then in another. And so now you're in a fractured environment across the country, perhaps. So I'm not sure that that's, you know, a better outcome.
To,
Oh, I
to,
agree.
to pull that thread a little bit, what happens at the state level, because states have largely said, well, we may enforce federal laws and rules.
mhm,
And there was actually a question that came into the chat that I think is somewhat related to, um, that says, can the CFPB just say, we aren't enforcing the LO comp rule, keep the law, but it's just not going to be used? And that's, I mean, I think that's potentially a scenario, but again, raises issue and concern from other regulators or potential authorities that may have
Yeah.
an ability to
Josh, as a
enforce.
practical matter, that's exactly the position the CFPB has had since 2015 when they had their last consent order. I mean, so it's been like 10 years since we've seen any real LO comp enforcement from the CFPB. And fundamentally, again, that boils down to the issue of who's harmed if you lower comp for a consumer at the point of sale or something like that, you know, because the loan officer lowers their commission. Who, you know, who's harmed if you do that? There's really no consumer harm. So I think the CFPB has been kind of like, well, we've got other fish to fry in the regulatory world. All right, well, you guys, unless you want to keep on this, let's move on. I think we're very fortunate to have two Texas attorneys here today, and I want to make sure we cover this topic because when I was in house, I guess I didn't really understand how different Texas was in terms of how it handles closings and the relationship between the sort of the Texas bar and document preparation, and maybe, you know, Peter, this is right. This is like right in your wheelhouse
mhm.
here. So I'd like you to sort of give the explanation. Maybe Troy can jump on top of that.
Sure. So, the longstanding law in Texas is that the preparation of legal instruments affecting title to real property is the practice of law and can only be done by licensed Texas attorneys. That was codified in a statute in the 80s. So we have Texas Government Code 83.001. And unlike a lot of other states, there's no party to the transaction exception and there's no for fee requirement. So it really, if you are a lender and maybe in another state, you are able to prepare the loan documents yourself, Texas would consider that the practice of law. Texas also requires the use of an outside attorney because the interpretations of the law have felt that in-house corporate attorneys would not satisfy that requirement. And the reason behind this, and a lot of people from outside the state are sort of surprised to find that Texas has the strongest homestead protections in the country. And this law was really passed in large part as a consumer protection statute. There were issues in the past with, not just talking about lenders, but unlicensed individuals who were out there preparing deeds, because it kind of was the Wild West a bit, and, clouding title, taking advantage of borrowers. So in Texas, if you are a lender, even if you're using, standardized forms, they need to be prepared or reviewed by a Texas licensed attorney. And one of the big, that's why if you think, why are all these doc prep law firms in Texas? It's, outside of the fact that our state's just large, is that we do have that statute and we do enforce it. And beyond just the legal requirements, because of the homestead protections, Texas lending laws are pretty complicated. And having knowledgeable Texas attorneys involved can help lenders comply with the law up front, mitigate your risk whenever you are selling in the secondary market, because all of the law firms that are in this space, we rep and warrant our work. So that can be risk mitigation. And then also, really, one of the big areas is home equity lending. That's where we see a lot of people that come in, a lot of lenders from out of state that don't really understand the complexities of that. And unfortunately, or fortunately, depending on your position, Texas home equity laws are enshrined in our Constitution. So it's not easy to change them, and they're very detailed, and they don't always seem to make sense at first blush. So the involvement of Texas lenders and legal counsel to prepare documents is sort of for that reason. And just beyond that, borrowers don't normally have their own attorney. So the only attorney really involved on both sides is the lender's counsel preparing the loan documents.
So when I was in house, one of the things we got sued for was, this was in Wisconsin, where I'm located, not today. I'm actually at the Hawaii Mortgage Bankers Conference. That's why I'm here. I'm speaking in a few hours. You guys will be having dinner or sleeping. In any event, the thing we got sued for was the unauthorized practice of law by virtue of charging a doc prep fee, which was interesting. We ended up settling that case because it was a weak case, but in Wisconsin, only the district attorneys could bring an unauthorized practice case. But you just mentioned that it was a consumer protection thing in Texas. And I'm wondering, do consumers have the right to bring an unauthorized practice case?
They do. So there's a private right of action, and also the Attorney General has the right. There were efforts in, I think it was the 90s, to have class action lawsuits against this practice of lenders preparing their own documents. But the Fifth Circuit ruled that the particularized facts of each situation meant that it couldn't be certified as a class. But yes, there is a private right of action for it. It is something that is sort of well known and accepted, and so the attorneys and the state bar do look to enforce this. And you have to think a little bit broader than, because it's a broadly written statute that in our industry, well, I'm a lender, I'm using Fannie Freddie documents, like what's the big deal? And putting aside, how do you decide what document you want? There's a lot of people out there and a lot of hard money lenders or other parties that are really, not playing by the same rules that everyone else is. And so this is an effort to sort of enforce that against them. And talking to some Texas regulators, a lot of what their action is sort of this, like private money lending that goes on in the state, or people holding themselves out as notaries that will also prepare deeds. Just creates a lot of issues with consumer protection.
Great. Troy, any other thoughts on that?
Peter hit it squarely. It's a complicated matter with big stakes for the people, the consumers, and then also for the lenders, right? And so I think a lot of people are surprised, and a lot of people may not even know that when they enter Texas, they need somebody like Peter's firm to. We don't do that sort of work, but Peter's firm to at least review the documents, and they've got their system set up, and it works in a lot of states. Texas is not alone in the sense of having attorneys involved. Of course, there's Peter, you probably know off the top of your head, I think it's 12 or 13 states total that have some sort of requirement for attorney involvement. But I do think that it is a surprise to a lot of lenders, and probably a fair number of lenders chugging along, not realizing that they may be, especially the ones who are doing 1 or 2 loans a month, that may not realize that they actually should have somebody involved.
Right.
Yeah, you go to use your documents that work in 49 other states, and you think it'll work in Texas, and it doesn't. And one kind of example of that is that when Fannie updated the home equity security instrument first in I think it was 2020, they actually inadvertently included provisions in it that violated Texas law. So the Texas Mortgage Bankers Association, other folks rang the alarm that, hey, like this needs to be corrected and fixed. And worked with Fannie to get that done. So, just because that someone else has done these documents doesn't always mean that they're done correctly.
Well, one quick point to add, I did maybe just as a point of caution and to confirm these requirements for attorney doc prep and compliance with Texas Constitution on homestead requirements, things like that, those apply beyond just the licensing context. So an entity that may be exempt from licensing, a bank or other depository, would still have to follow these requirements and not have a licensing regulator telling you these are requirements. So that's kind of just one point. And the second being Texas, most things unique, but the need to pay attention to the specifics in Texas, whether it be the attorney preparation of docs or points and fees requirements, or compliance with remote work requirements, or issuing a pre-qualification letter, a pre-approval letter that's codified and must be signed by the LO. And there are a lot of unique permutations of doing business in the state that using the wise advice of counsel and other compliance firms is really recommended.
Yeah, and just I'm sort of talking my book a little bit here, obviously, but if you sell in the secondary market, you're repping a warrant that you comply with all applicable laws, and if you're preparing your own documents, I mean, I'm not going to say I've seen it happen, but it's a theoretical risk you got to think about. And beyond that, there is a lot of value that we feel we add to lenders, as Josh said, dealing with the homestead issues. Will I have a valid lien on this property? Because they are tricky and there are a lot of exceptions. And homestead is not necessarily your primary residence. And we're dealing a lot with sort of intergenerational family transactions where title companies are basically taking, certain exceptions to like homestead rights of the seller that lenders don't realize sort of make, you sort of hanging out naked there if the borrower comes or the purchaser comes in and challenges it. So.
Yeah, maybe Peter, you could talk a little further about maybe your role in title clearance, because you can find some pretty unique title issues, I think, in Texas, and and helping the originator figure out, well, what do we do with this exception?
Right. A lot of survey exceptions, especially because we have the urbanization of the state. You get a lot of like blanket pipeline easements. What's my risk there? Beyond that, the big one, as I just mentioned, is homestead issues, taking exception to that. But because we don't use Alta forms, that's also sort of a little, bit of a wrinkle to lenders coming in that aren't necessarily familiar with the TLTA forms. And title companies are great. I love title companies, but from a lender's standpoint, like they're your counterparty. They're not your buddy. They're gonna sell you a policy. They're gonna charge a premium, but in whatever exceptions are in there, if you don't sort of understand them and understand your risk, like that can be kind of detrimental to you. So yeah, I mean, it works both ways with clearing title issues because it helps borrowers. So we deal a lot with complicated situations where we do work with the title companies to get clear title in the borrower's name, because these folks may have sort of inherited it. And in Texas, we use heirship affidavits, which I think is strange to a lot of people. So basically, you can just have an affidavit signed by someone who's familiar with the decedent who owned the property. It says, yeah, I know them, and they died without a will, and here's who their heirs are, and title companies will ensure that. And
Airship. I was misspelling that when I first heard you say it.
oh yeah,
So
not
I was thinking like a Zeppelin, like a blimp.
yeah. But yeah, Texas is it's surprisingly not the Wild West. It's got a very sort of complex statutory environment that we feel like we add a lot of value to, getting us involved beyond just the requirement that you have to.
Have you ever had somebody come in, it's a federal charter, and said, well, we don't need a Texas attorney. We've got a federal charter.
I mean, no one big. You get some small banks maybe here or there that have done that, but the large lenders have all taken, the large depository lenders have taken the position that they are subject to the practice of law requirements. And I think given sort of the case law that's come out recently, like with Cantero, that, because I think you had like, OCC that's basically like every state law is preempted, like we don't care what it is. That's been beat back. So I think that if you're a lender, a depository considering that, I think you have to look at like the current sort of Supreme Court background.
I think
before
you're
you take
being
that
kind.
position.
I think the last thing that would ever be preempted is the practice of law within each state. Like everything else might be preempted, but the lawyers are not going to let that happen in each state. I don't just they're
No,
lawyers
and I mean,
and they
and
control the law.
two, I always hesitate to bring this up because a lawyer, but we do have to pass character and fitness tests. Like there is this idea that you are an ethical person if you are a licensed attorney, and that you need to act ethically, and you're bound by the rules of ethics to do so. So, not saying that any lenders are out there acting unethically, but that's one of the thoughts of involving an attorney too, is that even though they are representing the lender, they still have ethical obligations to the borrowers, that come into play.
Great. Great. Anything else, Troy? Or we'll move on to the next topic.
Well, I would just add to that ethical overlay those ethics really do, and Brian, you know this well too. They do impact a lot of different areas of how people operate, and including just truthfulness to other people and to the courts. I mean, lawyers can't lie. There's a rule that says they can't. I'm simplifying it, but there is this overlay that you need to pay attention to, and so I think that does, despite the reputation that lawyers get in jokes and like, I think I always think of it as if I encounter a lawyer, usually I can have good confidence that I can trust that person.
Well, I think this is a good segue into the discussion about Townstone. Um, Perhaps.
Perhaps.
So I assume pretty much everyone's aware that the CFPB tried to essentially withdraw the consent order that they entered into with Townstone. Troy's firm helped with that case um, on behalf of Townstone. And just recently, the judge in that case, the district court judge in the, well, it's not a circuit judge, a district judge, Judge Valderrama, rejected that request to overturn or you know withdraw that consent order, basically saying this didn't really have extraordinary circumstances to justify undoing it. This was an agreement. This was a settlement. Why should I undo it? Everyone sort of is moving forward. It was all agreed to, and just because you had a change in administration, that's not enough for me to change it. I'm curious about your thoughts, Troy, what you can share, if without any confidential information with your clients, but
Sure.
go ahead and take it.
Yeah, and so yeah, no confidential information, of course, that I can divulge, but just as if you think about the rationale behind the judge's decision there, you can understand it, agree with it or not, you can understand it, that especially in this current environment that we're in, where so many of the the administrations that come in are really trying to undo what the last one did. It's always been the case. But I think even I get the sense, I don't know if you get it too, that it's more aggressive these days, and people can imagine a scenario where this happens now, and then, you know, whatever consent orders or whatever other final settlements are done, final decisions are done, you know, during this administration, a new administration comes in, Republican or Democrat for that matter, does it then create a scenario where each person the federal government comes in and says, yeah, let's undo that. We didn't really mean it. There's different factual scenario, or there's different views on how the world should work. So we should upend that case and just bring all of those zombies back to life. I can certainly see those arguments.
Yeah, you know, my read of it was the CFPB's argument was that the Townstone's owner was being discriminated against essentially on First Amendment grounds, that the reason why he was charged with the fair lending violations was because of his conservative views, and that was sort of a speech argument, a free speech argument as to why this should be overturned. And I think the judge was sort of saying, look, that's not enough. Like, first of all, it was initially brought under Kathleen Kraniger, who was, appointed by Trump. So
Right.
How is it that, you just have a different person now, and that's somehow viewpoint discrimination? Secondly, I think what he was saying is that that's just not enough in any event. And that what you really need to be able to show is some kind of malfeasance on the part of the CFPB in reaching this consent order, and that evidence of that was not provided. And I do think that there was some assertions at some point, and I remember on this show even asking, what are the receipts for that? Where is it that somehow Kathleen Kraniger was misled into pursuing this case by other attorneys? If there's if they're not sharing what they know with the CFPB director, that's problematic, I think. But there was no evidence presented of that. And so I think the judge was kind of saying, look, if attorneys were violating their ethical duties as part of this prosecution, then you would have some extenuating circumstances, but we haven't seen that. So I think that was where the judge was coming from.
Yeah.
Any other thoughts?
I do think that is right. And I mean, I'm very biased, obviously, in this case, and can only say so much, but I thought really it was a junk case from the beginning. And, fortunately we won at the district court in the initial round. And in fact, I thought at the appellate level, post Sloper Bright, I thought that more analysis would have been helpful at the circuit court level, to be able to give the district court judge some guidance before it ultimately settled.
Well, the circuit court decided one narrow issue, right? It was just the issue of whether prospective applicants are covered.
Yeah.
I understood that decision, but
yeah. And so I do think that there is like Peter was saying earlier, post Sloper Bright, there is a lot of opportunity for lots of different cross currents to be coming at us. And I think that, although I would have much preferred that this case not been brought in the first place, second of all, that I think we should have won anyways. But then also, I can understand from a policy perspective the concept of, do you want, again, I mentioned zombie cases coming back and years later being upended, and trying to figure out what those cross currents are added to all this other. I don't like it, but I understand the policy behind it.
But I just would say though, if you think about corner post, right, where the Supreme Court ruled that, previously it had been the statute of limitations was 4 years from the final agency action. And they said, no, 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 if you have later entrants, they need the ability to challenge the rule. So Supreme Court sort of, talking about those cross currents, Troy, has said, we don't care if a rule's 30 years old. Like if you, are a new company, have at it, challenge it. So it sort of, goes against that idea of like finality of this. And I know it's a little different with, private litigation and individual parties versus a rule. But when I saw the judge's decision in Townstone, I thought to corner post.
Yeah. Oh, that's a great point, Peter. Hey, let's maybe move on, unless somebody's got another comment about Townstone. Recently, Troy, you just wrote a note to your clients and friends about some changes that you saw in the Fannie Freddie guide relative to builder forwards and interested party contributions. This is an interesting area. I always get questions that I shouldn't say always, but I frequently get questions that have the intersection between regulatory law and just agency underwriting policies.
Right.
And really, what we're talking about here is a change to the agency policy, which doesn't really have the force of law. But if you want to sell loans to Fannie and Freddie and not risk rep and warrant liability, you want to make sure you get this covered. People come
That's
to
right.
lawyers and ask, are we in compliance with the guide on these kinds of questions? So Troy, maybe give us a little update on what you were writing about, and then we'll talk about it.
Sure. And so, and we get the same kinds of questions, I think, Brian, and Peter, you may as well, in fact. But builder forward commitments are intensely popular at the moment and have been probably for the past few years. We saw them, long ago, the early 2000s on up into the meltdown, and then they just kind of went away for a while. And they've made a fierce comeback in the very tight and restricted market that we're in the past few years. And so people hadn't really thought of them or seen them, I believe, for a long time. A lot of people that are in the business today never even had heard of them before. But suddenly there was this intense interest. As a general matter, if an interested party, including like a builder or a realtor or something
Brian,
like that.
I'm sorry to interrupt.
Yeah.
Just for what you had said, that these had kind of disappeared for a moment. I wonder if it wouldn't be helpful to give like the 10-word version of what is a builder forward.
Sorry. So yeah, a builder forward essentially is where, and this is what I think where Fannie and Freddie are going with this, is Fannie and Freddie are really trying to clarify what they view as a builder forward commitment. Essentially, the vanilla version of it is that a builder, and they're clear in the guides that it's a builder, not anyone else. A builder essentially goes to a lender. I'm simplifying a little bit, but giving the vanilla version, goes to a lender and says, hey, I would like to have, for my buyers, I would like to have less expensive financing for some defined period. And as long as they get a loan through you, they're gonna have this less expensive financing. And then I'm gonna advertise it so that people can come in and view my homes and see that, that's part of the marketplace, right? And in order to do that, the lender says, well, what's in it for me? Like, I'm not going to suddenly start, giving 2% lender credits on every transaction. So the builder and the lender work out a deal where the builder says, and this is what I think the GSEs are trying to get to be clear, is the builder says, okay, I tell you what, for forward transactions, so going forward, not in contracts you have in place today, but going forward, new contracts for a defined period, let's say 3 months, I, the builder, I'm going to pay you this chunk of money, and it's going to buy down some millions of dollars of volume in loan amounts to this particular rate, whatever they agree to. And because it's not tied to any particular transaction, then it's just kind of washed over. All of the transactions are in there, and it may be that the builder, I'll make up numbers, the builder gives $10,000 to the lender and doesn't do a single transaction. Well, what did the $10,000 get the builder? Nothing in my example. It also could be that they give the $10,000 and all of the money that is allotted is used up. But when you go to transaction one, you can't really say that $10,000 went to that transaction, because on transaction two, you'd have to go back and say, well, it wasn't 10 really on that one. It was 2 now, and each one's 5. And then in 3 and so on, and go down the road. This also creates the problem where it's not really disclosable on TRID documents, for example, because you would, if you tried to disclose it, you'd have to keep going back and revising your prior documents to account for this. And so the idea is that these really aren't identified as going towards a single transaction. It's over a wide variety of transactions. So that's my 10-word version of it, Jeff.
But more than 10.
That's, I think what's happened is that people relearned this or learned it for the first time and thought, my goodness, like that's a great way to get good financing for borrowers in this very harsh market. And so they started trying to find ways to expand it, not just to builders, to other people. They try to find ways to have it, the builders don't want to pay more than they have to, of course. So builders pushing people to, how about lenders to set up programs where maybe we can do it like it's just one transaction and I'll pay you and it's just for that one transaction. So I think the GSEs and FHFA also are concerned about that kind of an approach, because it very well could be that it's really be a payment in connection with a single transaction and should be subject to the interested party contribution rules, and they should apply as normal. That's a lot of words.
Yeah, I think, look, the problem it's trying to solve with the Builder Forward is that the agencies have placed limits on the amount of interested party contributions. And they, those have to be disclosed as buy downs if it's coming from a builder. But if you obtain the money in advance, you don't tie it to a particular transaction, then it can be a forward, and it's just, sort of baked into the cost of the house, as opposed to a interested party contribution. It's somewhat artificial in how the agencies view it, because if they wanted to, they could say, well, did you pay for this money in advance to lower the cost? Builders would rather lower the cost of the house through the interest rate than lower the cost of the house through the price. So it impacts appraisals. It should be something that I think it's very difficult to analyze the impact of, the buy down versus, I'm sorry, the forward cost versus the cost of the house. But this is what they're trying to do, and they're trying to refine their definitions now around that. And I think make sure that the big issue is that they don't want to tie to a specific transaction.
Yeah, I think that's right. And I think from a policy perspective, the government is trying to encourage more building and try to get more homes out there, so that the affordability problem that we've had for so long can be assuaged to somewhat to some degree. Now, the market's always evolving, of course, right? And so, right this minute, there's talk. It's a little difficult to know who's right, but certainly homes were sitting on the markets longer, and although it's all local in the real estate area, right? But homes are starting to sit a little longer, and I think some of the impetus to get new homes out there has been satisfied, but I think we're still behind in numbers of units, even though there's been a significant amount of growth past several months.
I'd add just one kind of comment. This to me is the type of issue that really exemplifies a team approach. I think we really need to involve our secondary markets team, our sales team, our legal team, our compliance team, our ops team, because the impact of a decision on one is going to ripple through the others. And this really is in my highly complex scenario, is the juice worth the squeeze process questions. There clearly is a need to provide lower rates and make homes more affordable. And I think that's driving a lot of this impetus behind the builder forwards. But I also, not that we're in it now, I've always thought about, well, how do builder forwards fare in a decreasing rate environment? That can be problematic because all the benefit of this forward commitment could be absorbed or offset by the fact that the market moved down. So again, I think there are so many moving pieces on this that if we focus just on one in isolation, we're going to lose the relevance of the other constituent pieces.
Yeah, and of course, one of the reasons that lenders like to do this is because if somebody is a builder has purchased, a couple $1 million of advance forwards, those are going to be loans, hopefully that that they're going to be getting, and so
Right.
you have to be careful with RESPA, of course, that you aren't giving a thing of value to a referral source in that context.
That's
We are just about out of time. Peter, did you have anything you wanted to add on this topic, or
Not really. I think I agree with everybody on the panel.
you see a lot of
Josh
forwards in
is
Texas?
oh yeah. I mean, we've got a lot of new construction out here, and builder forwards are very popular for the builders. And some of our builder clients have basically said from their point of view, it's the most advantageous way to provide an incentive to a borrower. That a dollar that goes into a builder forward results in much more savings to a buyer than any other incentive that they could give them.
All right. Well, I think we're just about out of time. 45 minutes. Thanks, Troy. Glad to have you on board. Josh, thanks again for coming. And Peter, always great to see you.
You too, Ryan.
All
Thanks
right.
so
Thanks,
much,
everyone.
everyone.
Thanks, everybody.
Thanks, everyone.
Yeah, great seeing you. Take care.